Today, we're going to talk about a rather disturbing case in the entertainment field, probably one of the most disturbing cases of the last 5 years. Vera Serova versus the estate of Michael Jackson and Sony Music. Michael Jackson died, and subsequently, his estate and Sony Music released an album called Michael, which promised to have previously unreleased tracks sung by Michael Jackson himself available for sale. And in fact, it became a runaway hit. But there was a problem. A lot of people who were big fans of Michael Jackson questioned whether, in fact, it was Michael actually singing or an impersonator. And three of the songs in particular, Keep Your Head Up, Breaking News, and Monster, were questioned. Ultimately, through an individual by the name of Vera Serova, a lawsuit was filed accusing Sony Music and the estate of Michael Jackson of falsely labeling these as the product of Michael Jackson. That lawsuit was 2014. The trial judge was satisfied that, in fact, the case could go forward. And the case wound its way through the courts until it went up to the Court of Appeal in California. And we got a bizarre and frankly wrong decision by the California Court of Appeal that said there was a First Amendment right to describe the song as sung by Michael Jackson when in fact it was not, which certainly doesn't put much teeth in consumer protection statutes if in fact you have a First Amendment right to misrepresent the product that you're selling. In turn, the Court of Appeal decision was appealed to the California Supreme Court, where the Attorney General of California, Becerra, filed a brief arguing that it was absurd to allow a First Amendment defense on a consumer fraud case. The California Supreme Court had entertained a briefing, an argument, and it had the case for 2 years. So we're now talking about a consumer fraud case that's been in progress since 2014, 8 years. Well, lo and behold, what happens in the last couple of days? Vera Serova dismisses her action. No harm, no foul. We've reached a settlement and all can be forgiven. Or can it? There never was a class certified, nor were there refunds that were ever issued to the people that purchased the album Michael under the false pretenses. What did happen, which makes you think that the underlying claims are true, is that Sony and the estate of Michael Jackson took off the internet the songs that were in question. This particular tactic of being right on the precipice of losing a major appeal and then dismissing the action and, for lack of a better word, buying off the plaintiff is one that has been used in the past. But there have been instances in which the California Supreme Court, on an issue of major importance, has decided to go through with an appeal, notwithstanding the decision of a single plaintiff to dismiss. If, in fact, the allegations are true and Sony and the estate of Michael Jackson made millions of dollars with a singer impersonator, shame on both of them. That is a disgraceful attack on the integrity of Michael Jackson's music. It's a disgrace to people in the music industry to behave that way.